So, today we're going to be talking about one of the most critical documents in real estate law, and that's the purchase and sale agreement, or simply referred to as the PSA. And this agreement is the foundational blueprint for nearly every real estate transaction. It lays out the terms, the conditions, the rights, the obligations, literally everything for both the buyers and the sellers. Now, after we look at it kind of in general, we're going to focus specifically on the PSA, and we're going to dissect their full purpose and nature. Okay. And a significant portion of our time today is going to be spent on the typical provisions that are found inside of a residential PSA. And hopefully it's going to give you a practical understanding of what these documents contain. And then we'll examine how some real property contracts can be terminated, and even more crucially, what legal remedies are available in the event that a contract is breached. So let's dig in. Now, before we dissect the PSA, it is essential that we ground ourselves in the principles of contract law. So, what exactly is a contract? Because at its core, a contract is a legally binding agreement. But what does legally binding even mean? It means that if one party fails to uphold their side of the agreement, then the other party has the right to seek an enforcement or remedies in a court of law. And that brings us to the second point, and that is a contract that's enforceable in court. And the enforceability is what distinguishes a mere promise from a contract. So like if your friend promises to help you move and then backs out, you likely don't have any kind of legal recourse. That's a social agreement and not a contract. Now, while it's true that many enforceable contracts are oral, there are some critical exceptions. The law, and specifically the statute of frauds, dictates that certain types of contracts must be in writing to be legally binding and enforceable. So contracts for the purchase and sale of real estate fall squarely within this category. And the purpose of the statute of frauds is to prevent fraudulent claims of agreements, particularly for significant transactions like a real property transfer. So imagine the chaos if someone could simply claim, hey, you orally agreed to sell them your house for $1, so hand it over. All right. Well, the writing requirement provides clarity, evidence, and hopefully reduces some disputes. But for any agreement to be considered valid and legally binding contract, you have to still have these essential ingredients no matter what, and they have to be present. And these are kind of like our fundamental building blocks. So if any of these blocks are missing or defective, then the entire structure of the contract can crumble, rendering it void or voidable or unenforceable. So let's talk about those. Now let's break down each of these essential ingredients in detail as they apply directly to a purchase and sale agreement. And first up is the offer and acceptance. This is the core of mutual agreement. So an offer is a clear, definite proposal, and it's made by the offeror to the offeree, and it indicates a willingness to enter into a contract on specific terms. So it's not just like a casual suggestion. It has to show an intent to be bound upon acceptance. So for instance, a seller sending a signed PSA document to a buyer stating the price and the terms is an offer. So an acceptance is the offeree's unequivocal notification to the offeror that they agree to the exact terms and conditions of the proposed transaction. So acceptance has to mirror the offer exactly. That's the mirror image rule. If the offeree tries to change any term, even a minor one, it's not an acceptance and it's now a counter offer, which effectively rejects the original offer and creates a new offer from the original offeree to the original offeror. So think of it kind of like a tennis match. The ball has to be hit back over the net without changing its spin or speed, right? So when the terms of the offer and acceptance match perfectly, we achieve a meeting of the minds or mutual assent. And this means that both parties understand and they agree to the same essential terms. And without the meeting of minds, there is no true agreement and thus there is no contract. Next is consideration. This is something of value that, and I use something of value loosely because each party has to give up something in exchange and it has to be something of value to them. So this is a legal concept that makes promises enforceable. It doesn't have to be money, though in real estate, Let's be honest, it often is. But it can be goods or services or even promises to do something or to refrain from doing something. The key is there has to be a bargain for exchange. So each party gives up something to get something in return. And in the PSA, the buyer's promise to pay a purchase price is their consideration, and the seller's promise to convey their property is their consideration. If a contract lacks consideration, it is often just deemed as a gratuitous promise and it is generally unenforceable. Next is the lawful purpose, and this is really straightforward. So, the subject matter or the purpose of the contract has to be legal. So, a contract to facilitate a crime or some sort of illegal activity is going to be void straight out of the gate. It's not going to be enforced by any court. For example, a contract to purchase a property for the sole and known purpose of, say, creating a meth lab or something would lack a lawful purpose and be unenforceable. Next is legal capacity. So for the contract to be valid, the parties have to have the legal ability to enter into it. That means that they have to be of sound mind and legal age. Take minors, for example. In Georgia, generally individuals under 18 are considered minors, and contracts entered into by minors are typically voidable by the minor. This means that the minor has the option to affirm or uphold the contract upon reaching the age of majority, which is 18, or to disaffirm it, which is to cancel it. The adult party to the contract, however, is generally bound unless the minor disaffirms. There are some exceptions, and those would be things like contracts for necessities, like, say, food or shelter. Now take mentally incompetent persons. If a person has legally been declared as mentally incompetent by a court, then any contracts they enter into are typically void. But if they have not been formally adjudicated but are suffering from some sort of mental illness that prevents them from understanding the nature and the consequences of the contract, then the contract may be voidable upon proof of their incapacity. Now, what about illiteracy? While illiteracy alone does not automatically void a contract, it can be a factor if it's coupled with fraud, misrepresentation, or a lack of understanding that prevented true assent. Remember the mutual assent or the meeting of the minds. So if a party cannot read the contract and relies on another's misrepresentation of its terms, then the contract might be voidable. In Georgia, the general rule is that you are presumed to have read and understood a contract that you have signed. What about intoxication? If a person is so intoxicated, doesn't matter, drugs, alcohol, whatever, that they cannot understand the nature and the consequences of the agreement, then the contract may be voidable. And the key is the degree of intoxication and whether or not it prevented a true meeting of the minds. Next is the legal authority. And this is particularly important in real estate transactions where parties may not be individuals acting on their own behalf. And it refers to whether the person signing the contract has the actual power to bind the party that they represent. And there are 4 major areas where this commonly impacts real estate, and it includes business entities. So if a corporation, LLC, or a partnership is buying or selling property, who has the authority to sign? It is usually going to be a designated officer like the president or the CEO for a corporation. It might be a managing member or a manager for the LLC, or it could be a general partner for a partnership. And you would need to verify that the signatory is authorized by the entity's bylaws or operating agreement. The second category is executors of estates. And an executor is appointed by a probate court to manage a deceased person's estate. So they must have proper legal authority from the probate court to sell estate property, which often requires court approval for the sale. Without it, the contract may be unenforceable. Then you have trustees, and a trustee manages assets that are held in a trust, and their authority to sell real property is strictly defined by the terms of their trust instrument. So you have to examine the trust document to make sure that the trustee even has the power to convey the property. And then you have the powers of attorney. And an individual can grant another person, an agent or an attorney in fact, a power of attorney to act on their behalf. So for real estate transactions, the power of attorney has to specifically grant the agent the authority to buy, sell, or convey, or actually or encumber real property. So a general power of attorney might not be enough for real estate transactions, and missing any of these ingredients can make the contract unenforceable, which is why verifying each point of these things is going to be a critical part of due diligence. So with that kind of foundational understanding of contracts, let's now specifically address the purchase and sale agreements, or the PSAs. So as mentioned, the PSA, it is the most common means by which property is transferred. So they are the initial crucial agreement that is going to set the stage for a real estate transaction. And the PSA is a type of contract between the seller and the buyer or the purchaser. And it contains the terms and the conditions upon which the property will be transferred. And that's why it is often called the blueprint for the entire transaction. Now, this PSA is going to govern the rights and obligations between the parties. And as we established already under the statute of frauds, has to be in writing in order for it to be enforceable. Okay? So this written requirement, it minimizes the ambiguities and it provides a clear record of the agreement. Okay? Now, it is very vital to clarify one very big common misconception. The PSA itself does not actually transfer ownership of real property from the seller to the buyer. The act of transfer, which is known as the conveyance, actually occurs at the closing, and that's through the delivery and the recording of the deed. But the PSA, this is a promise to make the transfer in the future, subject to the agreed upon terms and conditions. So it's going to cover the time period between when the contract is signed through the closing date. And that's often a critical period for due diligence. That's where you obtain financing. That's where you conduct inspections. You might have to resolve title issues, all of those things. So this executory period is where most of the action happens. And the PSA is going to dictate the timeline and the responsibilities during this phase. Okay. Now, a practical point here to note is that PSAs are not recorded in public records. They are private contracts between the parties. So recording them would be unnecessarily, I don't know, it would clutter public records, that had agreements that may or may not actually close on the property. So only the deed, which actually conveys title, is recorded. So just wanted to add that in there. Another thing, so contrary to popular belief also, PSAs do not need to be witnessed or notarized to be valid in Georgia for basic enforceability. Okay. Now, while they often are, especially if they are prepared by real estate agents, it is not a legal requirement for the contract itself. So the notarization is typically going to be required for documents that will be recorded, like deeds, things like that. It's simply to verify the signatures for public record keeping. And given the numerous deadlines and conditions that are contained in a PSA, it is a best practice for any real estate professional or anybody who's concerned with a real estate transaction to prepare a critical dates checklist to make sure that you keep track of all of those deadlines, because missing a deadline in a PSA can lead to some serious consequences that could include forfeiture of earnest money, loss of the deal, or even a lawsuit for the breach of contract. Now, within the PSA, there are two types of clauses that are so important for defining obligations and contingencies. And those are our covenants and contingencies. So your covenants are going to be your legally binding promises. And these are the core obligations that each party commits to fulfilling. So if a party fails to do their part and they do not fulfill any of the covenants that are contained in the contract, then that party is in breach of a contract. And a breach of covenant gives the non-breaching party grounds to seek remedies. Okay? For example, the seller promises to provide a clear title by closing. That's a covenant. okay? The buyer's promise to apply for a loan within a certain time frame is a covenant. So if the seller fails to clear a lien or the buyer fails to apply for a loan, they are in breach of their covenant. Now, contingencies, on the other hand, are conditions to a party's obligation to complete the transaction, and they create an escape hatch, so to speak, or a subject to clause. So if a stated contingency is not fulfilled, then there is generally no breach for a failure of that contingency. Instead, the party may be released from the contract without penalty, okay? So contingencies protect the parties by allowing them to withdraw if certain conditions precedent to the sale are not met. For example, a common contingency is the financing contingency. So the buyer's obligation to purchase the property is contingent upon them obtaining a loan for approval, okay? If the buyer applies for a loan in good faith but is denied, then the financing contingency has failed, and the buyer can typically terminate the contract and get their earnest money back without being in breach, okay? Another example is the inspection contingency, and this is where the buyer's obligation to close is contingent upon a satisfactory home inspection. So if inspection reveals, significant unacceptable defects that the seller refuses to fix, then the buyer can terminate the contract based on that unfulfilled contingency. And I actually should say that the seller refuses to remedy, because sometimes it might be giving money, like if it's carpet that needs to be, fixed because it's bad. Maybe they don't want to put a new carpet, but they'll give a carpet allowance for the person to go and get that. So just wanted to change that language. But the crucial difference is that a failure of a covenant leads to a breach, while a failure of a contingency leads to a termination without a breach. Now let's explore some typical provisions in a residential PSA. And as previously mentioned, there's no single set format, but you do have forms like those in the Georgia Association for Realtors, and they are widely used, and they contain the common boilerplate provisions along with spaces for deal-specific provisions. Now, I encourage you to review a sample one that is provided to you, or Google it, just so you'll know. But let's talk about some of those common components. First, you have the names of the parties, and this clearly identifies the full legal names of the sellers and the buyers. And this seems obvious, but critical. It is absolutely critical for enforceability. Next, you have the legal description of the property, and this is so important for clearly identifying the exact real property that's being transferred. It has to be specific enough to allow a surveyor to locate the property on the ground. And common forms are going to include meets and bounds descriptions. You've got lot and block numbers that are referencing, a recorded subdivision plat, or a street address that's often combined with a plat book and page reference. You have the purchase price, which is the agreed upon monetary amount that the buyer will pay for the property. You have the distribution of closing costs, and this section is going to itemize and kind of allocate who pays what, for the various expenses that are associated with closing, like attorney's fees, title insurance premiums, transfer taxes, recording fees, and even loan origination fees. And this is where we have a point of negotiation. Now, earnest money is a deposit that is usually a sum of money paid by the buyer, and it's held by a neutral third party, and it's often a closing attorney or like a broker's escrow account. And it's to demonstrate the buyer's good faith and commitment to the transaction. Now, it's not part of the purchase price yet, but it will typically be credited toward it, the price at closing. So if the buyer defaults without a valid reason, then that earnest money is often forfeited to the seller as liquidated damages. Seller representations regarding condition of the real property. Now, these are statements by the seller about the property's physical condition, and they often include disclosures about known defects, like is there a roof leak? Does it have an HVAC issue? Is there some sort of environmental hazard like lead-based paint? And this is a critical area for buyers to be informed and for sellers to avoid misrepresentation lawsuits. Georgia follows the doctrine of the caveat emptor, the buyer beware, in some respects, but active misrepresentation and failure to disclose material defects that are known can still lead to liability. Next is the seller's representation regarding title to the real property. And statements by the seller are intended to assure the buyer that they have a good and marketable title to the property. It is free and clear of undisclosed liens or encumbrances. And this is fundamental because buyers expect to receive a clear title. Going back to contingencies. So as previously discussed, these are conditions that have to be met for the transaction to proceed. So common contingencies, again, are going to include financing, where the buyer has to get a loan, the appraisal, where the property must appraise for at least a certain purchase price, an inspection, which is the satisfactory home inspection, and then sometimes the sale of the buyer's current home. Now let's talk about the closing date, the transfer of real property possession, and the closing attorney. And this specifies the exact date and sometimes the time the transaction will be finalized. You know, when the buyer will take the physical possession of the property, and it identifies the attorney and the firm that's responsible for conducting the closing. Now, beyond these core components, though, there are some other crucial provisions that are often included. So let's talk about those. First is prorations. So this clause is going to explain how certain expenses and income related to the property is going to be divided between the buyer and the seller based on the number of days that each party will own the property during a given period. So common prorated items are going to be things like property taxes, homeowners associations dues, if there's rental income, you know, sometimes even utility payments. But the goal is fairness. So each party pays for the time that they benefited from or responsible for the property itself. Next is the risk of loss. And this provision determines who bears the financial risk if the property is damaged or destroyed, like by fire, flood, or other disaster. But it's between the signing of the PSA and the closing date. And typically the risk of loss is going to rest with the seller until closing, meaning that the seller is responsible for repairs and is going to carry the proper insurance until that deed is transferred. And we have warranty transfers. And this is going to specify whether any existing manufacturer's warranties, like on the appliances, like systems, like your HVAC or your hot water heater, or there's any kind of builder's warranties on new construction, that will transfer from the seller to the buyer. Next is survival. And this clause addresses whether any provisions of the PSA will survive the closing. And generally, most of the PSA is going to merge into the deed at closing. This means that once the deed is delivered and accepted, then the contractual promises in the PSA are no longer enforceable, as if they are considered fulfilled by the transfer of the deed. However, there are some specific promises, like, say, a seller agreeing to repair something after closing, or a warranty regarding the roof must be explicitly stated to survive closing, or they become unenforceable. Next is the notice provision. And this clause dictates the proper method and address for giving formal notices that are required by the contract, like a termination notice or like a request for a repair. And strict adherence to this provision is critical for ensuring the legal validity of communication. Next is time is of the essence, and you've probably heard this before, but this is a powerful clause for contracts that makes all deadlines in the contract absolutely firm, okay? So if a deadline is missed when time is of the essence, then the defaulting party is in breach, and the non-breaching party can immediately have the right to terminate the contract and seek remedies. Without this clause, courts basically will allow for what they consider to be reasonable delays, which is subjective to the judges themselves. Then we have the successors and assigns. And this provision states that the terms and the conditions of the contract are binding, not only on the original parties, but also on their heirs, their executors, their administrators, their successors, and their assigns. And this ensures that the contract's enforceability, even if one of the party dies or transfers their interest, is maintained unless assignment is explicitly prohibited. Next, we have governing law, and this clause specifies which state's law will govern the interpretation and the enforcement of the contract. And for real estate, it's almost always the law of the state where the property is located. Next, we have the exhibits and amendments. And the PSA will reference any attached exhibits like a legal description, a property disclosure form, or say something like a lead-based paint addendum. But any changes or additions to the original PSA after it is signed must be done through a written amendment, which has to be signed by both parties. So oral amendments are generally not going to be enforceable under the statute of frauds. Then we have special stipulations. And these are highly customized provisions that are added to the boilerplate contract that are unique to the specific transaction. So they are going to allow for negotiation of terms that are not covered by the standard form, such as specific repair agreements, unique financing terms, or contingent sale clauses. And these are often drafted by attorneys or real estate agents in consultation, though, with their clients. You have the signature blocks, delivery, and acceptance, and this is where the parties formally sign the agreement. Now, as we said before, there is no witness or notary that is strictly, required for the PSA's validity in Georgia because it's not recorded. But proper delivery of the signed contract back to the offeror or to their agent is going to be necessary for acceptance and for contract formation. And last but not least, we have the defined terms. And many longer PSAs will include a section that's defining key terms that are used frequently throughout the contract. And it's often using shorthand to ensure some sort of clarity and consistency, and also to avoid repetition. Now let's talk about the various ways that a real estate contract can be terminated. First is a mutual voluntary termination. And this is the cleanest way to end a contract. When all parties, they come together and they agree in writing to cancel or terminate the contract. And that often occurs if, say, circumstances changed and both the buyer and the seller agree it's no longer in their best interest to proceed. A signed termination and release agreement is typically what will be used in these situations. The impossibility of performance. This is where an unforeseen event has occurred, and it's truly one that is beyond the control of the parties. And that event somehow makes performance of the contract objectively impossible, then the contract can be terminated. So, for example, if you have a contract on a house and a tornado comes through and it levels the house after the PSA is signed, but before closing, that makes it impossible for the seller to convey that agreed upon property. So the contract might be terminated due to impossibility. This is different from impracticability or difficulty. This is impossibility. Next is a material breach of contract. And this is where you might have one party who commits a material breach. This is going to be an action or an inaction that constitutes substantial non-compliance with the terms of the contract. And in those situations, then the non-breaching party typically has the right to terminate the contract. A material breach is one that is going to go to like the heart of the contract, okay? For example, a buyer fails to show up at closing with the funds, or a seller refuses to sign the deed. Those are substantial non-compliance with the terms of the contract, and they definitely go to the heart of it. And finally is the closing. And this is the most common way that the PSA terminates, and it's when we have a successful closing. So once the deed is delivered, then the purchase price is paid, and then all other conditions are met. The purpose of the PSA is fulfilled, and the contract effectively terminates. So, as noted previously, any unfulfilled covenants that do not specifically survive closing are also no longer required to be fulfilled by the party who made the covenants because, again, they merge into the deed. Now let's talk about what happens when a contract is breached and we need remedies. So a breach of contract is essentially a default, and that is a failure to uphold the covenants or promises that one has made in the contract. And when a breach occurs, the injured party can seek legal remedies against the breaching party. Now, it's important to remember here that the injured party generally has a duty to mitigate their damages. And that means that they have to take steps, reasonable steps, let me say reasonable steps, to minimize the financial harm that is caused by the breach. So, for example, if a buyer defaults, then the seller can't just let the house sit for years. They should try to find another buyer to lessen their losses. Okay. Then the injured party can also seek reimbursement of attorney's fees, especially if the contract contains a prevailing party clause or if the breach was somehow fraudulent or in bad faith, but that's going to depend on the state laws. So just a quick note on the parole evidence rule. This rule generally will prevent parties from introducing any kind of outside evidence like prior oral agreements or negotiations in order to contradict, to vary, or even to add to the terms of a written contract that is intended to be their complete and final expression of their agreement. This emphasizes the importance of ensuring that all agreements are captured within that written PSA. Now let's get back to those remedies and what's available for real estate. First is specific performance, and this is a very powerful equitable remedy, meaning that it's based on fairness rather than strict legal rights. So it is a court-ordered mandate that a party perform a specific act. So in this context, it is usually to go through with the sale or the purchase of the property as agreed upon in the contract. So specific performance is based on the premise that real property is unique and that money damages are just not an adequate remedy, okay? So because every parcel of land is considered distinct, simply getting money back might not allow the injured party to acquire an identical property, somewhere else, okay? So for example, if a seller gets a better offer after signing a PSA and refuses to close, then the buyer might sue for specific performance. They can ask the court to compel the seller to convey the deed to them. Okay. Now, an important note for Georgia, though, here is that the Georgia Association of Realtors form contract that is widely used has eliminated specific performance as a remedy that is open to sellers to seek, but it does still generally remain as an option for buyers in Georgia. Again, given the uniqueness of real property. Next is money damages or compensatory damages or pecuniary damages, whatever you want to call it. But the theory behind money damages is to place the injured party in the same monetary position they would have been if the contract had been honored by the breaching party. So this aims to compensate for actual financial losses. So to determine if money damage are an appropriate remedy, the courts will primarily look at two factors. First is the purchase price, as set forth in the PSA. And then they will look at the fair market value of the real property at the time of the breach. So if the buyer defaults, then the seller may only recover money damages if the fair market value of the property is less than the original purchase price. So let's assume that the purchase price of the property was $140,000, okay? And its fair market value at the time of the breach was $150,000, okay? So if the buyer defaults, can the seller even recover money damages? No, because the seller can likely turn around and sell that property to someone else for $150,000, which is more than the original contract price of $140,000. So the seller has not suffered any monetary loss based on fair market value, but has instead seen a gain. Okay. Now, if the seller defaults, then the buyer may only recover money damages if the fair market value of the property is greater than the purchase price. Okay. So we'll use the same exact numbers. So assume the house again, $140,000, and the fair market value is $150,000. So if the seller defaults, can the buyer recover money? Yes. And that's because the buyer would have suffered a monetary damage in the amount of $10,000, which is $150,000 for the fair market value, less the $140,000 purchase price. And this is a result of the breach of the contract by the seller. So the buyer would have to pay $10,000 more in an open market to acquire a property of the same value. So the money damages aims to make up that difference. Next is rescission and restitution. And the purpose of rescission and restitution is to cancel the contract entirely and to place the injured party in the same monetary position they would have been in had the PSA never been signed. And this is about undoing the transaction and restoring status quo. So, let's say we have examples for expenses for which the non-breaching party would be reimbursed, okay? Including the cost of hiring a lawyer, obtaining a survey, paying for the home inspection, title fees, appraisal fees, anything that's legitimate pre-purchase in terms of expenses that was incurred in reliance on the contract. This will essentially put the innocent party back to square one as if the contract never happened. And last, we have the liquidated damages. And this is a pre-agreed upon sum of money that is explicitly stated in the PSA that the parties agree will be paid to the non-breaching party in the event of a default. And the idea is that the parties at the time of contract formation try to estimate what actual damages would be in the event of default. And that's to avoid the difficulty and expense of proving actual damages in court. So in a residential real estate contract, the earnest money deposit serves as liquidated damages. So if the buyer defaults, the seller keeps the earnest money as their sole remedy. Now, here's something to note. When drafting or reviewing liquidated damage clauses, it is so important to avoid estimating too high of a figure, or it will be deemed as unenforceable by the courts because the penalty is too high. Courts generally won't enforce a liquidated damage clause if it appears to be punishment rather than a genuine, reasonable pre-estimate of potential damages. So the amount must be reasonably related to an anticipated loss. And we're almost done, I promise. So let's briefly look at two specialized types of agreements that involve potential future transfer of real property. And that is the option contract and the lease purchase agreements. So an option contract is a contract between a seller and an option holder. And the key feature here is that the option holder has the right, but not the obligation, to purchase a parcel of property at any time within a specified time period for an agreed upon price. That was a mouthful, I know. In exchange for granting this option, the seller is going to receive some form of consideration, and it's usually a non-refundable monetary payment. And this payment buys the buyer the option to purchase. So, for example, you have a developer who wants to determine if a property is suitable for a large project, but they need some time for zoning and environmental studies. So they can pay the landowner $10,000 for a 12-month option to buy the land for $1 million, okay? Now, the developer is not obligated to buy it, but if they decide to, the landowner must sell it for the $1 million. So if the developer doesn't exercise that option within the 12 months, they will lose that $10,000. But again, they're not liable for that $1 million purchase price. Now, the lease purchase agreement is a hybrid contract where a property owner agrees to lease real property to a tenant for a specified period of time at a lease rate, okay? Now, one thing that is critical to understand here is that the tenant also agrees to purchase the property for a specified purchase price at the end of the term of the lease. So a common feature is in these that a portion of the tenant's lease payments are going to typically be credited toward the purchase of the property, towards, say, the down payment or, coming off of the principal, whatever. So, for example, a tenant leases a home for 2 years at $1,500 per month with a total purchase price agreed upon at $300,000, okay? And the agreement stipulates that $300 of each monthly rent payment will be credited towards the purchase price if the tenant completes the purchase, okay? That's different from the lease option where the tenant has the option to buy but isn't obligated. In the lease purchase, the tenant is obligated to buy at the end of the term. So in this particular case, the purchase price would be 289,200 because they would get credits of 10,800 for the $300 per month for 12 months. And that's pretty much it. Just remember the PSA is where the promises are made. It's where due diligence timelines are set, and it's where the liabilities are defined. And mastering these components are going to allow you to competently deal with clients, draft robust agreements, and effectively navigate the complexity of real estate transfers. Let me know if you have any questions. Bye.